Alcohol can make people do crazy things. An entire convention filled with intoxicated people is an accident waiting to happen. In Connolly versus Nicollet Hotel, we'll explore whether a hotel hosting a convention could be held liable when a guest injured a member of the public. In 1953, the annual National Junior Chamber of Commerce Convention was held at the Nicollet Hotel. However, with free-flowing alcohol available at the convention, these guests were hardly refined businessmen. During the convention, objects were thrown from the hotel, broken bottles and glass had to be cleaned from the sidewalk and stairwells daily, property was damaged on 8 floors, guns were fired in the lobby, and a small alligator mascot was found on the 4th floor. On the convention's 3rd day, the hotel's manager issued a memo to his staff calling the convention the most harrowing experience they had ever had. He also wrote that the hotel had initially ignored the damage the guests had caused, but now requested that the staff report the damage so he could eventually attempt to recover the expense from the convention. The following night, before the convention's conclusion, Marcella Connolly was walking on a public sidewalk next to the hotel when she heard an explosive sound and saw something hit the sidewalk and the person in front of her. When Connolly looked up at the hotel, she was struck in the eye by a falling handful of mud. Connolly became blind in the injured eye. Connolly sued Nicollet Hotel for negligence in a Minnesota state trial court. The jury found for Connolly. Nicollet Hotel moved for judgment notwithstanding the verdict, arguing that it couldn't have prevented Connolly's injury. The trial court granted the motion, and Connolly appealed to the Minnesota Supreme Court.